Thank you, Mr. Chairman.
Thank you, Senator Lee. Next up is Senator Klobuchar.
Thank you very much, Mr. Chairman, and thank you. I had other hearings and things going on, but I caught up on your testimony, and I just want to thank you all for being here in this important hearing, and thank the chair for calling it. One of my focuses on guns has been on domestic violence. For too long, domestic abuse was considered a family affair. And they would say what happened in a house didn't have to come into the courthouse. We all know times have changed with the passage of the domestic violence bill, the reauthorization of it many times. But we also know that when a gun is present in the home, women in abusive situations are 5 times more likely to be killed, which is why, as part of the gun safety bill on a bipartisan basis, we put in a version of the bill that I have been working on with Senator Hirono and others for years to make sure that people that are convicted of domestic abuse can't go out and buy a gun the next day. As a survivor yourself, Ms. Glenn, can you first say more about the dangerous connection between domestic violence and gun violence? And then you could add on to that just your concern about the Bruin decision and what that will mean. Go ahead.
Thank you so much for the question. The concern, of course, is that what I stated earlier, which is that victims will feel less safe because there's the idea that at minimum, when and if I felt like I could do something about it, now I can't. I cannot get the gun removed. Secondly, I would say that we are also talking about abusive persons feeling a bit more freedom to take that few seconds to pull the trigger on a gun when there's domestic violence present by them. What we're seeing is widespread confusion, widespread concern about this particular ruling and what it will mean to the future. Mm-hmm. As we all know, domestic violence victims very seldom, if at all, call law enforcement simply because of the already present danger, particularly when there is a firearm in the home. Mm-hmm. The concern is really quite marked right now, what this will mean outside of that Fifth Circuit.
Okay, and I know, Mr. Lindley, you mentioned this in your testimony. Do you want to add anything?
Thank you for the question. With domestic violence and firearms, it's a lethal cocktail. You already stated the statistics that women are 5 times more likely to be killed when there's a firearm in the home with domestic violence. With that, there's also a danger towards law enforcement and just the greater community. So we need to really look at protecting those domestic violence restraining orders in order to ensure that women or other victims are protected, and we remove those firearms from an already volatile situation.
Okay, and I know you also are expert on this. So my state has passed a number of common sense gun safety laws to prevent convicted felons, fugitives from justice, and convicted stalkers and domestic abusers from getting a gun. And we also have this very strong tradition of hunting. It is a big part of our life with legal gun owners and people who are law-abiding. But yet, we've been able to differentiate those that shouldn't have a gun, who have broken the law, and those that have not. And so could you talk about how the Bruin decision complicates efforts by state and local governments to protect public safety?
Thank you. So California has a program called the Armed Prohibited Person System, which identifies individuals who at one time legally purchased a firearm, but subsequent to that purchase became prohibited due to a mental health issue, due to the restraining order, or some type of act of violence. That has been a very successful program, identifying people who no longer have the ability to possess firearms because of an act that they've done or a mental health issue. It doesn't deal with individuals who are still law-abiding. So with those things combined, you look at Bruin, and again, I'm not an attorney, I'm looking at this from a law enforcement perspective. that could muddy the waters with who might be having their restraining orders removed because of some act going back to 1791. Things were far different in 1791 than they are today.
Okay, my very last question, Professor Rubin, in your dissent in the Bruin case, in his dissent, you didn't have a dissent, you probably were thinking one. In the dissent in the Bruin case, which was Justice Breyer was joined by Justices Kagan and Sotomayor, he asked this question. He asked, will the court's approach permit judges to reach the outcomes they prefer and then cloak those outcomes in the language of history? Based on the cases that have recently applied Bruin, how would you answer Justice Breyer's question?
History does not speak with one voice when it comes to the tradition of firearms regulation. And one of the big risks of Bruin that we are seeing right now in the way that lower courts are addressing constitutional questions after that opinion came down last June is that courts are picking and choosing different historical laws to emphasize. They're construing them differently. They're reading history at different levels of generality, and they're pointing in opposite directions about what the Constitution means. So without more clarification about how exactly to do the Bruin test, there is a real risk that opinions will, cloaked in history, will actually be subjective.
All right, well, I will ask the rest of my follow-up questions on many on the boyfriend loophole bills and laws, implications of these cases on that, but I will do that on the record because I know my colleagues are here ready to ask. So thank you.
Thanks, Senator Klobuchar. Senator Blackburn.
Thank you, Mr. Chairman. We appreciate so much that you all are here. It's an important conversation to have, and we are grateful for your testimony. You know, the